Even if you don't remember signing an arbitration agreement in your lifetime, chances are you already have. If you've ever opened a bank account, signed a cell phone contract, rented a car, used Amazon or Netflix, downloaded an app, or even started a new job, that was a lot, well, you've probably signed an arbitration agreement. Arbitration may be quicker and cheaper than court, but it raises serious concerns about fairness, transparency, and due process, potentially allowing parties, particularly corporations, to bypass key legal protections. Today, I'll explain what arbitration is, examine its pros and cons, and explore how it can sometimes bypass the judicial system. Unlike a public courtroom with a judge or jury in litigation, arbitration is a private legal process for resolving disputes outside of court. Individuals and businesses have turned to arbitration and other forms of alternative dispute resolution methods because litigation is time-consuming and costly. As explained in Business Lab like Clarkson and Miller, in arbitration, an arbitrator or neutral third party hears a dispute and imposes a resolution on the parties. A key difference here between arbitration and other forms of ADR, like negotiation or mediation, is that the third party is imposing a decision rather than simply helping the parties reach one. There is binding arbitration, where the decision is legally enforceable, and non-binding arbitration, in which the arbitrator's decision serves more as a recommendation. Arbitration can be voluntary, but more often it's mandatory, especially in consumer and employee agreements, where many people are bound to mandatory arbitration without realizing it. So, while arbitration may seem like a flexible alternative to court, how does it actually benefit or harm those involved? Lawyer and journalist Barbara Kate Repa summarized the pros and cons to arbitration accurately. Many people turn to arbitration because legal costs are typically lower, and the process moves faster than traditional court cases, which can drag on for years. Unlike court trials, arbitration is also private, shielding reputations, and its relaxed rules can make it feel less intimidating. But unlike court decisions, arbitration awards are usually final, with very few chances to appeal, even if the arbitrator made a legal error. Repa goes on to state that some are concerned that the take-it-or-leave-it nature of many arbitration clauses work in favor of large employers and manufacturers. Arbitrators are often selected from a pool maintained by arbitration firms. In repeat arbitrator scenarios, such as employment or consumer cases, arbitrators may be perceived as biased towards companies that provide them steady business. Arbitration decisions are private and don't create public precedent, which limits legal development and public accountability. Because companies often write the arbitration clauses, consumers or employees may have little say or leverage in the process. But perhaps the biggest concern isn't just who decides the case, but how the system itself can sidestep public justice. It may be that the most controversial issue with arbitration is how it can be used to bypass the traditional court system. In her influential article, Diffusing Disputes, Professor Judith Rasnick critiques the Supreme Court's expansion of arbitration, arguing that it undermines public access to judicial decisions and erodes the development of legal precedents. Many companies include fine print in contracts that contain mandatory arbitration clauses. Thomas E. Carbonneau noted that it is now possible for a major bank, a car manufacturer or dealership, a financial broker, or any other economic actor to insert a provision for final and binding arbitration in a purchase agreement or service contract and make it indispensable to the transaction. This means you either agree or won't be doing business. In arbitration, there's no judge or jury, and courts typically do not review an arbitrator's decision unless it can be proven there has been serious legal oversight, such as fraud. Because arbitrators don't have to follow legal precedent, and because their decisions are private, this creates a kind of shadow justice system, funded and controlled by the parties who use it. Thousands of cases regarding consumer rights, civil rights, and various other subjects are being left out of our judicial landscape. In this sense, arbitration is creating a private system of justice with little to no oversight. We've looked at what arbitration is, its advantages like speed and privacy, and its serious risks, like limited appeals and lack of transparency. As arbitration becomes more common in everyday contracts, it's important that we, as consumers and citizens, understand not only how it works, but what we might be giving up when we agree to it. So next time you check a box or sign a contract, ask yourself, what rights might you be signing away?